The Senzo Meyiwa murder case holds a unique place in South Africa's contemporary legal and social landscape, not only because of the profile of the victim, beloved national football figure, but also due to the ongoing spotlight it has cast on investigation, prosecution, and overall trust in the justice system. The conduct of lead investigator Brigadier Bongani Gininda is now under public and legal scrutiny. This report investigates the exhaustive legal and institutional consequences that would follow if Gininda is found to have fabricated evidence or relied on hearsay in a manner constituting defeating the ends of justice. The analysis is structured to address the possible repercussions for the trial itself, Gininda's career, and broader mechanisms of accountability within the South African Police Service, SAPS, along with the statutory and constitutional underpinnings governing such cases. The SAPS regime and the administrative justice architecture require police officers to act honestly, impartially, and with full respect for constitutional rights, a fabrication of evidence by a police investigator like Gininda would therefore clearly constitute a positive, intentional, unlawful act aimed at defeating justice squarely within the offense's parameters. The same applies to deliberate reliance on inadmissible or knowingly false hearsay if it is used to deprive an accused of their constitutional protections. Section 217 of the Criminal Procedure Act state that admissibility of confessions is predicated upon voluntariness and absence of misconduct. Evidence fabricated or procured by improper means is excluded. The South African Bill of Rights, especially Section 35, guarantees the following critical rights to every arrested and accused person: 11. The right to remain silent and avoid self-incrimination. The right to be informed of legal representation and to have access to counsel. The right not to be tried on the basis of evidence obtained in violation of any right in the Bill of Rights. The right to a fair trial, including challenging evidence. Violation of these rights, particularly through investigative misconduct, may trigger judicial remedies, such as exclusion of evidence, orders for acquittal or retrial, and in serious cases, a judicial finding of mistrial. The accused would have recourse for violation of the right to a fair trial, civil claims for unlawful detention, false arrest, or malicious prosecution should their rights have been infringed as a result of Gininda'S actions. The statutory approach to hearsay evidence. Under the Law of Evidence Amendment Act 45 of 1988, hearsay evidence is, as a general rule, inadmissible, especially in criminal trials, unless one of the following exceptions applies. The parties agree to its admission. The originator of the statement testifies. The state's phantom witness, Absalom Zungu, was never called to testify, depriving the defense and the accused the chance to challenge it. What is your take on these? The defense has now submitted applications for Section 174 due to the discrepancies in the Meyiwa case. The state's inability to call Absalom Zungu is a red flag. The SAPS Discipline Regulations 2016, issued under the SAPS Act 68 of 1995, identify the following as serious misconduct: defeating the course of justice, Regulation 504, giving false evidence or statements, Regulation 453, falsifying records, Regulation 53BB. Sanctions for these infractions include dismissal, suspension without pay, written warnings, and entry into the officer's service record. Expeditious procedures apply to serious misconduct, and referrals to the National Commissioner are required for review and further action. If parallel criminal charges are warranted, disciplinary proceedings do not abate and may actually proceed simultaneously. If Gininda is found to have fabricated evidence or relied on uncorroborated hearsay, the court can remove the investigator from further participation in the case, recuse the prosecutor or even the judge if seen to be complicit or not impartial, order judicial review of all decisions premised on false or tainted evidence. If allegations against Gininda are proven, he may be prosecuted for defeating the ends of justice, perjury, fraud, or related offenses. Maximum penalties include significant fines and potentially imprisonment, especially in egregious cases or those with major public impact. Most likely, outcomes are immediate suspension and eventual dismissal from SAPS, loss of pension, and professional disqualification. Accused parties and perhaps other affected individuals would have standing to pursue damages for unlawful arrest, malicious prosecution, or loss suffered due to wrongful prosecution. South Africa is a signatory to the UN Code of Conduct for law enforcement officials and is subject to African Union recommendations and UNODC norms. Law enforcement officials must maintain the highest standards of integrity, impartiality, and respect for human rights. Fabrication of evidence, corruption, and torture are condemned as an affront to justice and must be met with swift investigation and sanction. Oversight mechanisms must be independent and credible, with effective reporting and accountability. Failures to align with these principles risk not only domestic legal consequences, but also reputational harm and potential international scrutiny. If Brigadier Bongani Gininda is found to have fabricated evidence or deliberately relied on inadmissible hearsay, the consequences would be severe across all spheres of justice. For the trial, risk of evidence exclusion, dismissal or retrial, violation of fair trial rights, and potential acquittal for accused persons who may have been wrongfully implicated. For Gininda, exposure to criminal prosecution. For defeating the ends of justice. And on possibly other charges. Virtually certain dismissal from SAPS, loss of future employability in law enforcement, and reputational ruin. For SAPS and South Africa's justice system, institutional credibility will be further eroded, compounding existing public mistrust. It would place intense pressure on SAPS, IPID, and the MPA to reform their internal disciplinary, oversight, and prosecutorial practices. For the accused and other aggrieved parties, civil remedies, including damages for malicious prosecution or wrongful arrest, would be available and could succeed if the requisite elements are satisfied. These consequences illustrate the vital importance of investigative integrity, not only for the rights of the accused and for justice in a single trial, but for the legitimacy of law enforcement in democratic society. Institutional reforms, meaningful oversight, and the upholding of both national and international standards are essential to restoring and maintaining both justice and public trust. The case will resume on 25 August 2025 in pursuit of justice for Senzo Meyiwa. The whole world is waiting. With all the discrepancies, do you think Section 174 will succeed? What are your wishes for Gininda? He is found to have abused his powers. Let me know your thoughts in the comment section down below. Hit the like button, share the video, and kindly subscribe. Thanks for watching. I'll catch you on my next upload. Skybridge checking out. Bye.